Good morning, everyone. Thank you, everyone, for coming. My name is Miquel Peguera. I'm an associate professor of law at the Open University of Catalonia in Barcelona. And this panel is organized by the research group on law, science, technology, and society at the Vrije Universiteit of Brussel, and the FWO project called Public and Private Use and Online Sphere in Copyright. First of all, I would like to thank Irina Baraluk, Sari, Depreeuw, and Professor Serge Goodwith for inviting me to chair this panel. I'm really honored for this. And the panel will deal with the notions of public and private, both in copyright and in the fields of privacy and data protection. And of course, in each field, these notions have their own rationale and their own tradition. For instance, in the field of copyright, the notion of public is crucial to establish or to qualify some acts of exploitation, such as the communication to the public or making available to the public. The ACJ actually has been wrestling with this concept in a number of judgments lately, and sometimes leading to somewhat unexpected developments. In addition, for instance, of course, the notion of private is key to determine the potential scope of the private exception, a private copying exception, which member states may only grant for reproductions made by a natural person for private use. Of course, in the field of privacy and data protection, the dichotomy public-private is of course crucial in many respects, including this new right to be forgotten thing. Then on the other hand, information and communication technologies make it increasingly difficult to draw a precise line between what is private and what is public. For instance, sharing some copyrighted content with family and friends may fall within the private copy exception. Nonetheless, what can be considered a close circle of friends and relatives when you are sharing contents within a peer-to-peer network or within some social networks, or to put another example, in the privacy and data protection field, to what extent a user's online activity may fall within the so-called household exemption provided by the Data Protection Directive. Then on a different note, technology makes it possible to police some acts of that take place in private, which some acts that take place in private, which poses the question of whether there's a reasonable expectation of privacy in some cases by the user against, for instance, with regards to peer-to-peer protocol. And well, now how different the different notions of public and private in each field actually interact between copyright and data protection, and in particular, to what extent privacy and data protection rights might shield or protect a user from some copyright enforcement strategies. For instance, may a user rely on her privacy rights to build a private sphere that may protect her, in practice, enlarging her freedoms to use copyrighted content beyond what is traditionally accepted under copyright norms? Well, to tackle all these issues, we've chosen a particular format for this panel that Sari will explain, and the panel will be moderated by Sari Depreeuw. She's a postdoctoral researcher at the Interdisciplinary Research Group on Law, Science, Technology, and Society at the Vrije Universiteit Brussel. She specializes in intellectual property rights, in particular copyright and new technologies. She graduated from the law faculty at KU Leuven in 2002 and completed an LLM intellectual property law in KU Brussel in 2006. In 2011, she received her PhD from the Vrije Universiteit Brussel. Currently, she is working on the FWO project, Public and Private Use, an online private sphere in copyright. And she's also working as an attorney at law, and she's a member of the Brussels Bar. The panel, as she will explain more in more detail, will consist of two dialogues, each between two scholars, which will discuss the topic from either the point of view of copyright or the point of view of data protection. And the first dialogue will be between Professor Severine Dusollier, who will take the copyright point of view, and with Professor Maurizio Borghi, who will take the privacy and data protection approach. Severine Dusollier is professor of law at Sciences Po in Paris. Before joining the Sciences Po faculty, she was a professor at the University of Namur, where she taught intellectual property, IT law, property, competition law, and media law. She was the director of CRIT's Research Center in Information Law and Society at the University of Namur. She also teaches at the CEIPI, University of Strasbourg, and is a member of the Belgian Council of Intellectual Property. With other copyright European professors, she founded the European Copyright Society to voice the opinion of academics on copyright in the European Union, and her current research relates to intellectual property and mainly on IP limitations, the public domain, and the commons. And Maurizio Borghi is a professor of law and director of the Center for Intellectual Property Policy and Management at Bournemouth University. Before that, he had been lecturer at Brunel University Law School and research fellow at Bocconi University of Milan. After having received his PhD in 2000 from Bocconi University of Milan with a thesis on historical and philosophical foundations of copyright law, Professor Borghi has researched on various aspects of copyright with the aim of developing a right-based understanding of the information society. In this perspective, he has also expanded his interests in e-privacy and data protection law, and his more recent monograph, Copyright and Mass Dissertation, co-authored with Dr. Stavroula Karapapa, also present in this panel, was published by Oxford University Press in 2013. So,
yep.
Maybe now explain a little bit more of the
good morning, all. We have chosen, well, we had the opportunity to organize this panel, but we chose not to have this traditional panel, if you want, but instead to have two dialogues. So we hope to have a bit of a discussion while starting from a clear point of view, either from copyright point of view or from the data protection privacy point of view. First, we will have a dialogue between Severine and Maurizio, where Severine starts to explain what this private space, public space, how that is conceived in copyright, and then we hope that this point of view will be challenged by Maurizio from a point of view of privacy and data protection. So where we came from organizing this panel was that the observation that the private space and the public space used to be very clearly distinguishable. It used to be very clear, at home, I'm in my private space. In the street, I'm out in the public. Different rules apply in one space and in the other space. But now, there's this continuum. We hop into the private space, out of the private space, depending on which perspective we're taking. We're in the street, we're in the public space, but we're listening to music that only we can hear. So it's a bit of both. At the same time, we're sharing all our information on Facebook, on Twitter, what we are listening to. We can share our playlists with our friends, even if those friends consist of hundreds of people. So it's not always clear what we are doing while we are doing it. So from that perspective, we think it's interesting to see where we came from and where we are going from, the point of view of these different disciplines. So I'll hand over the microphone to the first duo, starting from the copyright perspective. We will have a dialogue, and then after that we will have the opportunity for some Q&A with you. If you have interesting remarks that you want to share with us, there will be an opportunity for that.
Okay. Thank you. Okay, the rule was not to use a PowerPoint, so I disobeyed the rule first. And I prepared just but it's not really a PowerPoint with a lot of text. It's more to illustrate my point. And really for the dialogue, and so I will let Maurizio to interrupt me each time you want, or if you want to precise something or contest something, please do so. So I've been asked to just introduce the topic by showing the public-private divide in copyright, and okay, this is the public-private dividing line in copyright, or is it how we usually introduce it? On one side you will have the copyright sphere that is in charge of the public sphere, and on the other side you would have what escapes from copyright, and it would be the private sphere. And if you go into the details, actually it means that when you do communication to the public, when you do a reproduction, you do it in the public sphere, it is within the ambit of copyright. But there are some things that are outside of copyright when you do a private communication, meaning in most countries when you communicate a work within your family circle, and the private copying usually is seen as being outside of copyright. So this is easy to understand, but actually this is not true. This is a myth. Because that's right, you have on the side of the public sphere, you have the exclusive rights to the public, the reproduction, but if you look to private copying, actually it is within copyright, because it's only an exception to copyright. It's an exception, and it is an exception against remuneration. So it means that even an act of private copying is considered to be, for copyright purposes, an act of reproduction that normally copyright owners could control, authorize, or prohibit. But the law has decided to carve out this type of reproduction from the control of copyright owners, but to compensate them with a reproduction. Okay, so you could say it's mostly outside of copyright. But as it's still a defense, it's not something that completely escapes copyright power, and it needs to comply with some requirements, and those requirements have multiplied in last years. First, it is submitted to a very strange thing that we have in copyright, that is a three-step test. It is something that limit the exceptions to certain conditions, and namely not to harm the normal exploitation of a work. But if you let a lot of people make private copying, maybe it will harm the sales of the work, because people will get access to the work through private copying and not through normal operation of the market. So there is a risk there for the private copy. Then recently the European Court of Justice says that the private copy is only admissible when it is made from a lawful source, so from a copy that has been authorized. So private copying could still be restricted under copyright rules. So what is left completely in the private sphere is the private communication, the communication within the family circle. Okay, this is shrinking. But then there are also some public acts of use of copyrighted works that escape copyright through the rule of an exception. You have a lot of public use that are subject to exceptions and that are motivated by public interest. For instance, public use made by schools, public use made by libraries. Two persons in the panel have written a lot about it. The parody exception. So there are a lot of exceptions that are justified by some interest that prevail over copyright. Okay, I put them in the green box, the box that escape copyright, but we could also discuss they are also subject to many conditions and requirements, so they are also mediated by copyright rules. But then, as Sari said, the public sphere and the private sphere are just blurry in the internet, and you have social networks. That means that you might think that you talk to your friends, but are your friends really your private sphere, or does it extend beyond the private sphere? Any online expression, because it is made by a public media like internet, makes you enter the public sphere, not the private sphere anymore. And before the internet, you just express yourself, and you didn't use any media to do so. And so the media actually were reserved to commercial actors or to public actors, but they were not reserved to the individual. So actually, the copyright could only go control the public use of those media, and we're really dealing with commercial actors, public actors, but not with individuals. Now everybody is a public talker, and then the speech of everyone is concerned with copyright. You have the peer-to-peer sharing that Miquel has evoked, that also you think that you share works with your peers, with your friends, but actually no, it's a public communication, a public sharing. You modify a work because you want to make a point, you want to make some creation, and you put it online. You could have done it before and nobody would have known about it. It would have been something that you did in a private sphere, but nowadays you can put it online and everybody knows about it. So all those things that find an analogy before the internet, and that expression was not concerned by copyright, nowadays is completely covered by copyright. That means that actually in the red box, I don't mean by red that copyright is bad, don't misunderstand me, but in the red box of copyright you have, again, communication to the public, reproduction, but any private expression when using a public media like the internet, the private copying, as I said. On the other side, you still have the private communication, but it's restricted to not so many things, actually, and still some public use subject to exceptions. I will add another thing in the green box. Nowadays, you have increasingly, and that rejoices data protection issues, the private sphere that is organized for copyright purposes, limited by contracts, by DRM, by technological measures. What I mean by that is that your private sphere is becoming also a market. And before, economic actors sold works, and once you bought work, you were using them in a private sphere, and copyright just stopped at the entrance of your home. But nowadays, copyright enters because those economic actors that sells you files, digital files, with identification systems, and actually they think they sell the fact that you will be able to use what you have bought within the private sphere. But that private sphere is not defined by the walls of your houses or the link that you have with your friends. It's defined by the device that you have with that particular brand. And that means that if I buy music online, I will be able to use it on that device and another device, maybe on 5 different devices. And those devices define actually my private sphere. So I mean that that private sphere where I should be able, for copyright purposes, to do a lot of things is not completely mine anymore, because it's restricted, is organized by economic actors, who might not be copyright holders, by the way, but who are able to constrain and decide of what I could do, and within that private sphere that becomes a device-based personal sphere and not really a private sphere. So it's still in the green, but actually it's also contaminated by a bit of red. So actually, the dividing line between public and private, in my point of view, is not a useful criterion anymore in copyright, and we should move to something else. And that, I can open the discussion. I think that we should move to something else that would be a criterion of exploitation. There are other people who have said that. Sari has made an excellent PhD about it. So, but I think that what is important now is to look at who is making who is extracting value from something and who is extracting economic value from copyright. And it could be a new dividing line where economic actors that takes out value out of work could be controlled by copyright. That would leave the individual who share value for expressive purposes, for social purposes, for cultural purposes, individuals and institutions, would be left out of copyright as they used to be. And they would not be just within copyright because of technological features of the internet that makes every act of use a copy, that make every act of expression a public expression. And for instance, that would mean, I will give you one example, the cloud computing that doesn't appear in my slide. Cloud computing can be seen as a private locker when you put your stuff. But actually, there are a lot of economic actors who make money out of cloud computing and out of those lockers and control what you can do. So within those lockers or within these services based on cloud computing, I think copyright should be able to decide who is actually extracting value when making copies for you, when making available content for a lot of persons in that private sphere that actually is not a private sphere. And my point would be that even the private copying should come back to a no copyright zone. That means, and that will be contested a lot, that means that for me private copying should not be an exception, but a limitation to copyright. So because it's a private act of use, when it is done with something that has been lawfully bought, there should not even be a remuneration to compensate the copyright owners. And that is a very sensitive issue because nowadays copyright owners earn a lot of money from private copying, and that will mean a big loss for them. So I know that I'm on a tricky field here.
Thank you for your brilliant presentation, and I will try to pick up some of your points from the data protection perspective. The distinction between public and private is fundamental, of course, in data protection because it defines the very subject matter of data protection. In my understanding, there are essentially 3 stages in data protection law where this distinction becomes crucial and where it becomes controversial in today's digital environment. The first stage is at the level of data processing. And as has been mentioned already, the Data Protection Directive has an exception, the so-called household exception, meaning that when processing is made by a natural person in the course of a purely personal or household activity, this data processing would fall outside the scope of the directive. Now, this has been discussed in some cases by the European Court of Justice, and it has been construed very narrowly, in the sense that, for instance, apparently the distinction between a commercial or non-commercial use is not relevant, and this makes sense because what matters is whether this data processing has an impact on the data subject, and this does not necessarily require that the data controller engages in a commercial activity. Or other situations where, for instance, in a recent case where CCTVs were used to protect a personal property, but the CCTV incidentally also included images from the footpath, which is a public place. And again, the court ruled that in this case, this activity could not fall within the scope of the household exception if a CCTV includes also images of persons that are in a public place. A second stage where the distinction between public-private becomes relevant is in the definition of the nature of the data. We know that the definition of personal data is very broad. Anything, in principle, can be a personal data. The jurisprudence has been discussed long whether only data that violate the right to privacy should be covered, or only data that do not have any impact on private life and on the right to privacy of persons. And here, I mean, there is a very long discussion in the position developed by UK courts has been much narrower than the position applied by other continental European courts. In the UK, the tendency is to say that only personal data that affect the right to privacy are covered by data protection law. As a matter of fact, this is no longer true, and in fact, data protection is covering a number of personal data that have nothing directly to do with private life, with private and personal life, with the private sphere. The third stage where this distinction becomes relevant is the definition of the data subject. And here again, Miquel was mentioning the right to be forgotten, and in the recent and much debated Google Spain decision, where the right to be forgotten was, we have to say, introduced officially into data protection law. One of the features to be balanced when assessing the right to be forgotten is the role played by the data subject in the public life, meaning that the right to be forgotten applies only to data subjects that do not have a role in the public life. And again, how to distinguish between private and public life. Every person has both aspects. Now, for instance, we are all private persons, but in this moment we are also at the same time playing a role in the public life. Or a person might be a private person and at some point of time becoming a public figure. So, and this it will be interesting to see how this will be applied in the context of search engines. Now, trying to find some analogs between these three features, the three main concepts of data protection in copyright. Well, in the first case of the personal or household exception, we found a very clear analog with the private copy exception. And more or less, the definition is the same. Besides the fact that, as Severine was saying, the private copy exception comes with the right of remuneration, while the household exception does not have this feature, is a pure exception. Both are narrowly construed. And in both cases, there are certain activities that tend to become important in today's digital economy that do not fit comfortably or do not fit at all within this exception. And I'm speaking, for example, of data mining activities. Because if a private person collects data from, let's say, from social networks and process this data in a purely personal or household activity, this would fall squarely within the exception. But what if this activity is done systematically in order to extract information of user behavior or whatever, or for research purposes? This is an activity that in principle might not have any impact upon the privacy right of the data subject, but still cannot fit this exception because it is clearly not a private, is not a personal activity, and most important, is not performed by a natural person. And the same can be said in case of copyright. Data mining, text mining requires a specific exception. They do not fall within the private copy exception, even though they might not have any impact on the right holder, or even no economic value is extracted from this activity. Then the second stage, the nature of the data. Here we can find an analog in copyright law with the distinction between published and unpublished work. and with what in the continental Europe is called the right of first publication. In copyright too, the definition of the subject matter definition is broad, unlike in the UK, where the UK has a closed list of subject matter protectable by copyright. But in other European countries, any original expression is in principle copyright protectable. And this is similar to the definition of personal data in data protection. Again, how to distinguish between published and unpublished work might not be so easy nowadays in the digital environment. What about a draft that has been published for a conference and submitted to a conference? Is this a publication or not? What a blog post? What about these forms of expression that are shared perhaps only in a circle of Facebook friends? Is this a publication or not? And as to the third stage, the data subject, here it is more difficult to find an analog in copyright. Here is where data protection and copyright divide. Because in copyright law, there is no corresponding concept in the sense that the nature of the author does not have any impact on the protectability of the work. It does not matter whether the work has been produced by an amateur or by a professional. It does not matter whether the author plays a role in the public life or is a private person. Both expressions are copyright protected, are equally copyright protected, even though the nature of the author might influence certain court decisions. And this is something that it would be interesting to investigate. I give you just an example. There is an American case where the discussion was about whether the processing of works by Turnitin, the software that detects plagiarism, processing of students' coursework is fair use or not. Well, if you read the decision, my impression is that the court was strongly influenced by the fact that the authors in question were students, were not professional authors, they were not expected to publish their work, let alone having some revenues from the exploitation of these works, and this weighted significantly in favor of the defendant in this case and in favor of a finding of fair use. So an interesting issue would be to see how and whether and to what extent copyright is also influenced by the nature of the author in this case. Yes, I can stop here. Thank you.
That gives us a bit of time to see if there's questions or remarks from the public so far. Yeah.
Thank you. Hi, Michael Bernhack, Tel Aviv University. Thanks for the discussion. And it made me wondering whether when we use the terms public and private in copyright law and when we use the terms public and private in privacy law, data protection law, is it the same? And we might engage in that sort of discussion, which, you know, we use the same terms, but I think they mean something different. Not quite sure what, but that is one point. And then I'm trying to seek for something that is common in both legal fields. And I think, at least under some conceptions of both copyright and of privacy, that is a matter of control. And that shared goal, if we so understand each of the two fields, might be helpful in explaining something which otherwise can be a bit bizarre. And I mean the case of revenge porn in the US, where an ex uploads and publishes photos of usually his girlfriend, ex-girlfriend, etc. As a matter of privacy law, in many cases, she doesn't have much to do, but if she can claim that she has copyright in the photo, she can send a notice and and have it download. So I was wondering whether there seems any useful way to sort of understand the relationship between public-private copyright privacy by searching for shared goal. Control might be one of them.
Okay, maybe we'll do a tour, see if there's other questions.
Many thanks. Oreste Pollicino, Bocconi University, Milan. I think that I found really interesting and fascinating the discussion. Maybe there is a missing element that it's in a way planned to take out of the discussion now, but it would be interesting to know from the speakers which would be their opinion about this, the missing element that is freedom expression, because it's clearly difficult, I think, to investigate in depth the common difference between these two legal fields, where if freedom of speech is not in the pictures, because it's clearly from both sides it's a really crucial element that can, let's say, cause a lot of change, just not just from a comparative point of view, but also from a technological one. So I would like to know why it's been excluded, and if very briefly how they could put in the pictures. Thanks.
Hello, I'm Monica Tarazona from DG Research and Innovation, European Commission, and my question goes to Severine. Very nice your last slide, but my question goes for the term of no copyright when there is some form of exploitation escaping copyright. When you say this could happen for exceptions for public uses like research or libraries, etc., but I'm thinking, for example, on the text and data mining exception, that how would that sit when research is more and more increasingly made by public-private partnerships? Would that also fit in? I mean, don't we have a wrong focus here about exploitation and commercial use, rather than thinking same exploitation as original work, whereas with research, the exploitation, commercial exploitation, could lead to other different types of exploitation which are very valuable for society in general.
Thank you. I think we'll keep it at that. So we have 3 questions about the notion of control in both copyright and data protection privacy. Second question, how about the role of the freedom of expression in the overlap, and how about the exception for text and data mining?
Yeah, to answer first to Michael Bernack, I'm not a specialist on privacy as you are, but that's true. I think the notion of private is completely different in privacy and in copyright. And my first guess would be that when we define the private in copyright, we think about, and many of us have used the word sphere. We talk about a private sphere. Communication is outside of copyright when it happens in the private circle, in the family circle. Private reproduction is defined as the reproduction that you make within your house for your own purposes. So it's about your needs and your place. And I would say that privacy is at least as how I understand it, the private that is about you, about a person, you know, so it's completely different. In copyright, when you think of something that is about you, actually it can trigger copyright protection, because when you do something that is about you, maybe it could be considered as being something that bears the imprint of your personality, then it's original, then it's copyrighted expression. You know, so the point of view is completely different, and I think that that's right. We shouldn't maybe approach things considering the private is the same. But I think that there is a move around the notion of the private in copyright that really restricts the copyright as what you do as a consumer. You know, it's not about to some extent, that doesn't explain all the changes, but to some extent, I think the private now explains that what is private is what you owned and what you use as the consumer who bought it. You know, and this is a completely different notion of the private. It is a commodified notion of the private. And to that extent, maybe there is some convergence with the privacy field. I don't know. We could discuss it, I think, for a long time. For the freedom of expression, maybe I can.
I would not respond to the question of Michael because it's too difficult. I don't have an answer. As to the issue on freedom of expression, well, my opinion, totally unsubstantiated, is that this issue has been a bit overestimated in copyright, the clash between copyright and freedom of expression, slightly overestimated, let's say, not at all overestimated in privacy and data protection. So I think that the question is more relevant in data protection law than in copyright. This, I mean, the distinction I made is at the third stage, at the stage of defining who is the data subject, that, to my understanding, the need to balance the two rights, the right to privacy and the right of freedom of expression, comes into play. And of course, the right to be forgotten is at the core of this balancing act.
Can I answer to the last questions? For the last question, I wasn't subtle enough in my last slide. When I said the exploitation should be about when economic value is extracted out of a work, it shouldn't be enough, because when you also extract expressive value it should be refined in a way, but I think it's not about commercial or non-commercial. For me, it's not the same, you know. But for instance, to come to your example of text and data mining, when you do text and data mining, for me, I was really surprised 2 years ago when that issue arrived at the copyright table. I said, what are we talking about, you know? It's just because we have this strictly technical definition of reproduction that, of course, when you scan some content, you will make copies of everything that you scan. Yes, okay, this is how technology works. But actually, you don't extract or exploit any value with those content. You only use the information that is there, and eyes have been doing it for centuries, you know. And now that we ask a machine to do it because it will be more quickly and more efficient, suddenly we are in copyright, and it doesn't make sense at all. So whether it's done for commercial or non-commercial purpose shouldn't be the criterion. The criterion should be that actually you don't exploit anything when you do that, but just scan documents and take information out of it. So my economic factor is not about commercial, non-commercial.
Yeah. Yes, I agree with you, except that it's not easy to determine whether data mining or text mining activity is exploitative or not, because the dividing line again between purely research activity and commercial activity is not so clear. If you know that in text mining is mainly used, for example, in pharmaceutical research, and it is difficult to determine whether this is purely research or commercial. There is another point that is, to my understanding, a bit overlooked in this, is that these activities of gathering data, and this data might include personal data and copyright works, which works in the same way. They work as data in both cases. These activities might generate new forms of enclosures, not to say monopolies, that can be facilitated by the fact that there are exceptions. You were mentioning cloud computing. Cloud computing is an example of a service that relies on the private copying exception, but at the same time permits to accumulate billions of bits of data that might become a value for a company, and this might pose some competition law issues.
Yep, thank you very much for this interesting discussion. I'm taking two notions into the next discussion. We've heard a lot about this exploitation. Maybe a nice question would be how this notion of exploitation, how that matters in data protection and privacy. Do we only need protection against exploitation of our data? And a second notion that I found very interesting is this device-based privacy sphere. Is this a useful concept for data protection, and does that correspond more or less to the notion of private sphere in privacy? Oh, sorry.
Okay, so just the introduction of the next speakers was missing. So the dialogue will be held between Professor Orla Lynskey, who will speak from the perspective of privacy and data protection, and Professor Stavroula Karapapa, taking the copyright point of view. Orla Lynskey is an assistant professor at the law department of the London School of Economics, where she teaches courses on digital rights, cyber law, and competition law. She is a graduate of Trinity College Dublin and the College of Europe in Brussels, where she also worked for a number of years as an academic assistant. She obtained a PhD in EU data protection law from the University of Cambridge. Prior to her PhD, she worked as Cardell's case handler for European Commission and for a US law firm in Brussels. Orla's current research focuses on the EU Charter right to data protection and its implications for EU policy making. And Stavroula Karapapa is Associate Professor of Law, an Executive Co-Director of the Center for Commercial Law and Financial Regulation at the University of Reading. Her research focuses on intellectual property law and with an emphasis on copyright doctrine and policy, most notably with regards to the challenges on digitization, big data, and the internet. She is also interested in the protection of personality rights in the online world and has written on issues of European intellectual property law, such as the harmonization of copyright exceptions, copyright issues of text mining and data analytics, the legal and regulatory issues of mass digitization, and select issues on the community trademark.
Great, thank you. So I'll try and not trod on the path which Maurizio has already very clearly outlined. So approaching this public-private dichotomy from a data protection perspective, my initial reaction was that there wasn't much to say because the material scope of data protection law doesn't differentiate between public and private data. But then, you know, as we've already heard, once you dig a little deeper, I think the scope of the rights of individuals under data protection law isn't dependent on the public-private divide, but the scope of the obligations of data controllers is very much dependent on that public-private divide through this exception for data processing for purely household purposes. So what I'll do is maybe outline a little bit my reasoning for saying that, and I think try and argue that this actually has quite paradoxical effects on the private sphere. So, you know, the over-application in some ways of data protection can have a weird narrowing effect on the private sphere. So first of all, with regard to the material scope of the data protection rules, as we've kind of already heard, the definition of personal data is data relating to any identified or information relating to any identified or identifiable individual. So clearly there, on a textual interpretation, you have no distinction between the public and the private. And actually, I would argue here that this is one of the things that differentiates data protection from the right to privacy, where actually the public or private context in which information is revealed can actually determine whether or not the right to privacy applies. So you've got case law on this from the European Court of Human Rights, like the Peck case, where you can have some rights to privacy in a public place, However, that's very much a context-dependent assessment, and you might ask questions like, does the individual have a reasonable expectation of privacy? Whereas we don't ask those questions in data protection law, with the result that data protection law applies more broadly to the public sphere than the right to privacy. And actually, I think the example of revenge porn, which was just given, is a good one of that, because you might not be able to argue that if you sent an explicit photo to somebody else and they later make it public, that you have a reasonable expectation of privacy. However, it would fall entirely within the scope of the data protection rules. So in that sense, I don't think the public-private divide is relevant to the material scope of the rules. But as we've already kind of discussed, it's a myth to then say that this divide isn't relevant at all. And the place where it does become relevant is when you look at the application of the exception to the data protection rules for purely data processing for purely personal or household purposes. And what you can see there is that exception has been narrowed to the point of being almost obsolete. So this started with the case at EU level of, poor Mrs. Lindqvist, who was prosecuted criminally for putting some information about a local church online, with the idea that that information, because it was online, was accessible to the world at large, and therefore that publicity aspect made it fall outside the scope of this exemption. And then, as Maurizio has already outlined, the Court of Justice has further narrowed that exception just before Christmas in the Rhinus case, where it held that the capture of CCTV footage for what could only be very legitimate purposes, which is personal security, the capture of that footage on outside a man's house in the public pavement outside was not able to benefit from this exception. Now, if you look to the rationale then, because Sari has asked me to elaborate on what I might think the rationale for that is, you're going to get quite difficult consequences from the Rhinus case. Because on the one hand, you can say that at a time when it's not inconceivable that everyone will have their own personal drone in 5 years' time, the judgment could kind of mitigate any potential for digital vigilantism, so people taking their kind of personal security into their own hands through CCTV and various other monitoring techniques. But equally, I was trying to think of, what would this do to the tourist who wanders down the South Bank in London, as happens regularly, and takes a video footage of everything they see as they go along, the wonderful sights and the thousands of people that you encounter there on a Sunday morning. And what if they then upload that information? Would that not, on the same logic of the Rhinus case, benefit from this exemption? So I don't think the court really considered there the freedom of expression implications, which have already been mentioned. And this, I think, begs the question of how data protection then deals with that public-private divide in this context. And again, in the freedom of expression context, you've had UK scholars like Jacob Rowbottom arguing that we need to distinguish between what he calls high-level expression online and low-level expression online. And so high-level expression being kind of journalistic expression, and low-level expression being the random comment on Twitter. And that discussion was very lively in the UK after the Chambers case, where a man was, an attempt was made to criminally prosecute a man for, what was a stupid tweet, but not a criminally offensive tweet, where he threatened to blow up an airport because his flight had been cancelled because of the Icelandic volcano. And that sparked a lively discussion about what should be looked at as high-level or low-level speech. And I wonder whether we could think about high-level or low-level data controllers in this context. Because with the Rhinus discussion, we've all become data controllers quite easily because the scope of the purely household exemption has been narrowed so much. And as I said, that leads to this paradoxical result that the over-application of the data protection rules could actually have a chilling effect on freedom of speech, but also will narrow the scope of the private sphere and what personal data we can process in our private capacity. So it's a very fine line to be balanced there. And then just picking up on the points that Sari had mentioned, is commercial exploitation, is that maybe where we draw the line on whether or not this exemption for purely household processing applies? Now, this has been argued before the court. So the court rejected that in the Lynskey case, where Mrs. Lynskey said, I'm processing this personal data because I'm a member of the local church, and the kids who were going forward for confirmation thought it would be nice to know who the members of the parish committee are. I've got no economic gain in this situation. And the court rejected that argument then. So it doesn't look like that kind of economic exploitation argument would be compelling. And then the question is, should it be compelling? And again, I think maybe the revenge porn example is a good one here, because if somebody posts revenge porn on a particular social networking site, they have nothing to gain financially from that, but there is clearly a breach of the data processing rules or the data protection rules. So economic exploitation might not actually be the helpful dividing line here. And then finally, on the question of the very interesting point raised by Severine about how DRM techniques are actually narrowing the private sphere by kind of tracking use even when it is for kind of personal purposes. To try and find an analogy there with data protection is perhaps quite difficult, but I think this comes down to the role of code in the technological sense that Lessig meant, as something that can either limit your rights under data protection or limit the extent to which your rights are violated. So the design of a particular program could equally have that inhibiting effect in the data protection and privacy context as it has in the copyright context. So just to kind of wrap that up, I think Sari wanted Stavroula and I to have a big argument, but I don't know if that'll happen, because although on its face it looks like data protection is in some ways unconcerned with the public-private divide, the exception for processing for purely personal or household purposes renders that kind of argument redundant. And actually it's something that seems to be causing equally as many problems in the data protection sphere as it is in the copyright sphere. So going back to the question asked in the abstract for today, what can copyright learn from data protection? I think you might ask the opposite question, what can data protection learn from copyright?
Thank you. I will go back a bit to what Severine discussed earlier and the issue of exploitation, because I think that this is very central in drawing a distinction. It's a matter of control that Michael mentioned earlier, and I think that probably any distinctive line has to be drawn there, and that's not only a matter of scope of rights, but it's also a matter of justification of rights in the first place. And although we might not have a very clear indication, for instance, with regards to the private copying exceptions, as to which is the rationale. Is this about stopping monitoring the private sphere when someone is just going ahead and reading a book, and what they will do with this book afterwards? Will they photocopy? Will they give to others to read onwards? And this would be more or less a matter of privacy. But still, this goes beyond the point of justification of an exception. It probably is also a matter of scope. And even in the area of copyright law, there is no particularly clear indication as how we have to construe the private sphere. I have done extensive research on that, and I have seen that various national courts have constructed the concept of the private sphere in various ways, and they have drawn various criteria and various factors in the equation. So it goes back to the relationship that the person who made the copy has with the person that they gave the copy to, or they made the use of the copy. For instance, they played some music. It might be the relationship that the person who made the copy has with the right holder in a way, or for instance, that was the case in Raphael hotels, and the fact that you can have TV sets in hotel bedrooms. Does this actually amount into an infringement of copyright law? Do you actually have to clear a license for that? Because, as a matter of fact, there can be 1 or 2 people residing in a hotel room at a time. Still, the successive publicity that this use might have has an impact on the scope of any kind of on the scope of right as well.
And also, most recently, we have a case in the United States, the Aereo case, where the focus was on the relationship of the party to the work. So mainly it is a matter of ownership. Do you really own the copy? And so on and so forth. And what is the kind of lawful use that can be made in that context? And yet, then again, because there is some sort of blurred distinction and some relationship with the right to privacy, it is also a matter of the space where a use is made. So is this a public place? Is this a private space in the first place? And how this actually influences any considerations of that nature. It's what Sari mentioned a moment ago when she mentioned that we might be walking down the street, which is a public place, and then again we might be listening to music on our earphones, and that is sort of blurring any kinds of considerations. And there have been so many factors that have been put into this equation that you cannot really have a clear test as to what amounts into a private use in copyright law, despite the fact that public use in the form of exploitative use, from a purely interpretational aspect, the fact that almost all rights in copyright law are addressed to the public, with the exception of the reproduction right, but then again, you have the private copying exception that counterbalances that. But still, all the rights are addressed to the public in the form of an exploitative use, because this is when the rights take effect, and in certain jurisdictions, you might actually have the requirement that the rights have to be published before any kinds of rights take effect. Still, however, with all these parameters that are put into the equation, you see, at least in the scope of the private copying exception, that the use, according to the directive at least, Information Society Directive, has to be private and non-commercial. So it means that one requirement counterbalances the other, and in a way, they have to be read in conjunction. Usually, you cannot have a private use that is commercial. So, for instance, let's say that I'm giving a copy of something that I've made to a friend. I might not be expecting any sort of remuneration in return. Still, however, it is more likely that when a use is public, it will be commercial, without this being necessarily the case. Still, so, more recently, however, this element of exploitative use in copyright law has been highlighted by the fact that it is likely that this distinction has become, to an extent, redundant. So beyond the scope of the private copying exception, which is important in the sense that you have to clarify what a private sphere is, otherwise, the Court of Justice recently, in terms of the communication right, has drawn the emphasis on the concept of the new public, which is, the way I've read the cases, is neither a public nor a private sphere anymore. It is something totally new, and this is mainly having to do with exploitative considerations. What the Court of Justice has done in a line of cases, going back to the case of the Rafael hotels that I mentioned earlier, to more recently cases that have to do with hyperlinks, is that they say that an activity, a communication to the public is not going to be infringement before it reaches a new public. So it is not anymore whether this is a public use or not a public use, or even a private use. It is whether a new portion of the public has been reached in one way or another, and this means that even a private sphere might not be as private as we assumed once, and unless the private copying exception applies, then there would not be any concept of privacy to that end. Of course, the most recent decision, the Svensson decision that had to do with hyperlinking content, and afterwards the best water order that had to do with videos, still in those cases, the way in which the concept has been construed is a bit controversial. And there are other criteria that are included within the test in order to fine-tune the concept of the new public. But what we see more recently in copyright law is that the concept of exploitation has become predominant, because I think that this is what underlies, at the end of the day, the new public requirement, and it does not matter. It does not matter any longer whether the use is going to be private or public, in a sense. So, yeah, thank you. Thank you.
Do we have any questions from the room? No, not even for. Everything was perfectly clear. Nobody wants to challenge anything. We have an agreement on this. Okay, then I will just thank all the speakers for this very interesting debate, and thank you for your presence. Enjoy the rest of the conference. You still have a question? Ah, just made it.
Thank you very much. This is a very good point, and thank you for the suggestion. I was sure that somewhere in data protection there is some privileges for users of publicly available data. Now you confirm that the German law has this. I will investigate this more clearly. I mean, under the shared goal theory that Michael was mentioning before, one might object that when you place personal data, for instance, on your Facebook page or on your Twitter account, you share this data for a purpose, and this purpose might not be consistent with the use that a third party might make for data analytics, for monitoring consumer behavior, etc., all this kind of research. So this might be a limitation of the legitimate use. But thank you very much for this suggestion.
Closing words?
Well, it looks like we should close this panel. It's been really interesting. There are a lot of things that have come out, and I just would like to thank everyone in the panel and all the public, and thank you very much for coming and for all this interesting discussion.
Thank you.